Okay, good morning. I'm Trevor Morrison. I'm the Dean of the Law School here at NYU, and it's my pleasure to welcome everyone for this Birnbaum Women's Leadership Network discussion on the Lilly Ledbetter Fair Pay Act 10 years on. I think it will be 10 years to the day tomorrow that the act was signed into law. So this is an important topic, and we have a terrific lineup of speakers throughout the day to address it. As you all know, the Lilly Ledbetter Act was the first piece of legislation that President Obama signed in his first term in office. I'll say on a personal note, for those of us serving in government at the time, I can remember well the sense of excitement and optimism on the day that the legislation was signed, both because it was, I think we all thought, an appropriate and important response, legislative response to the call really that Justice Ginsburg issued in her dissenting opinion in the Ledbetter case, to fix a malfunction really in the statute and to make it importantly more equitable, but also a sense of optimism that the legislation might just be the beginning of an important set of changes extending much more broadly than the particular issue covered by the statute and that was at issue in the Ledbetter case. And I suppose part of the work of today will be assessing how that's gone, what progress has been made, what remains, whether there's been a change in the direction, the opposite of progress as well over this last 10 years. So I just do want to thank, before turning things over to the first panel, the leadership of the Birnbaum Women's Leadership Network, in particular Sheila Birnbaum, and also our trustee Sarah Moss, who really was, together with Sheila, one of the visionaries in forming this, as well as our faculty co-directors of the network, Melissa Murray and Valencia Morada-Wurgler, who are here. And without further ado, let's jump to the first panel on fair pay, which is moderated by our own Deborah Archer, who we're thrilled has joined our faculty this year. So again, welcome and enjoy the day.
Thank you. Good morning. Good morning, everyone, and welcome to our discussion on fair pay. My name is Deborah Archer. I'm a member of the faculty here at NYU Law School. As you know, for over 50 years, federal law has required that men and women receive equal pay for equal work. And the Lilly Ledbetter Fair Pay Act was intended to ensure that women would be able to overcome hurdles around transparency and other impediments to being able to enforce their federal anti-discrimination law rights. Yet today, despite the fact that women are participating in the labor force in record numbers and have made incredible gains in education, unequal pay remains pervasive. Women are paid less than men for the same work, with women in every occupation facing a wage gap. Women are overrepresented in low-wage jobs and underrepresented in high-wage ones. And women often have unequal opportunities in education, mentorship, training, and career choices. I have a few statistics to help put all this in context. They're going to be familiar to many of you, but maybe new to some of you. According to the National Women's Law Center, women in the U.S. who work full-time, year-round, are paid only 80 cents for every dollar paid to white men. And when you focus on women of color, the disparities increase and are even larger. Black women make only 61 cents for every dollar paid to their white male counterparts. For Native women, it is 58 cents, and Latinas make only 53 cents. And while Asian women working full-time are paid about 85 cents for every dollar, the wage gap is substantially larger when you look at subgroups of Asian women. But the concerns we explore today are far beyond just fair pay. They also go to the challenges of advancing a broader vision of workplace fairness. And we have a wonderful panel of experts to help us understand the gender wage gap, including those racial disparities that I mentioned, and to also talk about what we need to do to advance that broader vision of workplace equity. First, we have Sarah Brafman. Sarah is a staff attorney at A Better Balance, where she works on legislation, litigation, and public education efforts to advance pregnant worker fairness, workplace equality, and fair pay. and also to end sexual harassment in the workplace. Sarah is an alum of NYU Law, and while she was here, she was the editor-in-chief of the NYU Review of Law and Social Change, co-chair of the NYU Law Students for Reproductive Justice, and she also interned at the American Civil Liberties Union Reproductive Freedom Project and with the National Women's Law Center Healthcare and Reproductive Rights team. Next, we have Professor Rachel Arno-Richmond, and she is the Chauncey Wilson Memorial Research Professor and Director of the Workplace Law Program at the University of Denver Sturm College of Law, where she teaches in the areas of employment law and contracts. Prior to joining the College of Law, Professor Arno-Richmond was an associate professor at Texas Wesleyan University School of Law and a visiting associate professor at Temple University School of Law. And before teaching, she served as a judicial law clerk to the New Jersey Supreme Court and practiced employment and commercial law at Drinker, Biddle, and Reith LLP in Philadelphia. And next, we have Vasu Reddy. Vasu is Senior Policy Counsel for Workplace Programs at the National Partnership for Women and Families. There, she provides legal research, writing, and analysis on key workplace policy areas. While in law school, she worked on reproductive rights issues as a legal intern at the National Women's Law Center and the National Asian Pacific American Women's Forum, and as an officer of Georgetown Law Students for Reproductive Justice. Prior to law school, Vasu worked at Sanctuary for Families, a New York City nonprofit dedicated to serving survivors of domestic violence and sex trafficking and their children. And then finally, we have Zev Eigen. He's the founder and chief science officer of Syndio, which is the world's leader in data scientific applications to solve today's business problems. At Syndio, Dr. Eigen combines his expertise in labor and employment law with his deep experience in data science, predictive modeling, and economic sociological research. He previously was a full-time law professor at Northwestern University School of Law, and he's also the former global director of data analytics with Littler Mendelsohn and former senior counsel for labor relations with 20th Century Fox Film Corporation in Los Angeles. So welcome to all our panelists. The format for today is that each of the panelists will speak briefly to help us get a broad foundation of the issues that are involved with the fight for fair pay and equitable workplaces. And then we'll have a discussion amongst us to explore those issues a little deeper. And then finally, we're going to open it up to include all of you and take questions from the audience. So we're going to get started with Sarah. We're going to get started with Vasu.
Hi, everyone. Thank you all for having me here for the Lilly Ledbetter anniversary. I'm going to talk about the number, the wage gap number, because around this time of year and around Equal Pay Day, there's always a lot of confusion about what the number actually measures, and that leads to a lot of criticism. That is not really, that kind of misses the subtleties and the nuance of what the number really means, and what it means for women and their families. So the number, as Deborah recited, is when you take the median wages of women working full-time year-round and compare them to the median wages of all men working full-time year-round, you find that women make 80 cents for every dollar that the men make. And those numbers, when you compare them across race, are even more stark. 61 cents for every dollar for black women compared to white men, 58 cents for Native American women compared to white men, and 53 cents for Latina women compared to white non-Hispanic men. So this number, it's not giving you a one-to-one comparison, and I think that's where a lot of the confusion comes from. It's not saying we have a store manager who worked at Walmart for 4 years who's a woman, and a store manager who worked at Walmart for 4 years who's a man, and their pay is apart by 80 cents. That's not to say that there is not discrimination at Walmart. There very, as many lawsuits have put forward, there's quite a possibility that there's discrimination at Walmart. But but it's not what the number is actually showing you. What the number is actually measuring is the subtle inequalities and inequities that build up over the course of women's lives. So when we're looking at this number, what we're seeing is subtle racial and gender bias that may lead to someone not being offered a promotion. We're seeing women who lose their jobs because they needed time to recover from childbirth. We see women who leave their jobs because they were harassed for transitioning. And women who are concentrated in minimum wage jobs that are of comparable worth to higher paying jobs, but because they have a high concentration of women are paid less. The list goes on, and the wage gap number is really useful in showing the full extent of these inequities all put together. But that's also kind of its drawback. It can't show you all the pieces of the picture. It can only show you the big overall piece. And so the obvious remedy that we've started with going for is remedies to discrimination, and that's absolutely a correct place to start. As Deborah mentioned, even when you compare women and men who have the same occupation or work in the same industry or have the same education levels, the wage gap still persists. And so there is clearly something there beyond just women's individual choices. And so the Lilly Ledbetter Fair Pay Act and state legislation all over the country is tackling that discrimination piece of the picture. But it can't tell you about all of these other causes. It can't tell you about how lack of childcare affects the gap, or about how harassment and other forms of bias at the workplace affect the gap. It can't show you each piece by piece what it is measuring. It also can't tell you how the gap ripples out into other parts of women's lives, and it affects their ability to afford childcare, housing, food, healthcare, and other basic needs. That means also consequences for the women's families. Women are or primary breadwinners in mothers are or primary breadwinners in 2/3 of families. And that means they bring home a significant portion of their family's wages. So when the woman's earnings are affected, that means that her family is not able to have all the things that it needs to survive and thrive. It also can't tell you how these inequities affect women over the course of their entire lifetimes. So for each paycheck, women have less money to contribute to savings and retirement. They have less flexibility to leave their jobs if they're being sexually harassed. They have less money to save up when they do have a child or when they do have a family or medical event, and need savings to fall back on if they don't have paid leave at work. So that's kind of the big, broad picture of the wage gap, and I just wanted to lay that out there because some of the other panelists are going to talk about the individual aspects of it, and I think it's really important that we start out with a clear understanding of what the number is measuring and what it really means, not just as a dry number, but as a really as a tangible impact on women's lives and their families.
Thank you. And then we'll have Sarah.
Hi, everyone. I am Sarah Braffman, and as Deborah mentioned, I'm a staff attorney at A Better Balance, which is a national legal advocacy organization working to ensure that no worker has to choose between their caregiving responsibilities and their economic security. Equal pay is obviously an issue very much at the forefront of our minds because, as Vasu was mentioning, and thank you, Vasu, for laying the foundation for us about what these numbers look like, caregiving and caregiving responsibilities are a major contributor to the wage gap. And what we do is we try to think about equal pay in the sort of specific ways like the Lilly Ledbetter Act does, of how you drive at discrimination and the numbers specifically, but also kind of stepping back and looking at a broader, with a broader lens of all the issues that contribute to the wage gap. So you've already heard a lot of numbers, and I'll just add a couple more, and then I kind of want to flesh it out with what this looks like for women and women that we see every day, because we're a policy advocacy organization, but we also run a free legal hotline and do direct services. So we represent clients who are facing caregiving discrimination. So numbers. In New York City, we did a report that was called the pregnancy penalty. So I'm sure a lot of folks here have heard about something called the mommy penalty, which is a statistic that when women have children, they see a 4% decrease in their salary. Contrast that with men who become fathers and see a 6% bonus when they have children. And that's really owing to stereotypes around men and women's caregiving responsibilities, right? That women are viewed as no longer reliable employees because they are going to be mothers. Men are going to be more responsible workers because they now need to provide for their families. So those kinds of stereotypes perpetuate the wage gap. But we kind of took a step back and wanted to think about what happens when a woman becomes pregnant. And what we were finding is that women were being pushed out of the workforce when they would request a modest accommodation to stay healthy and on the job. So oftentimes a woman's doctor might say, you have a 50-pound lifting restriction. Now, if you work at Walmart, you might be lifting, 75 pounds worth of pallets every day, and you might need light duty for a couple of months to stay healthy, but also earning a paycheck. So take New York City, for example. Women under 35 without children in New York City make 96 cents to every dollar a man earns. Now, 4 cents is still not sufficient. It should be 100% of what men make. But women between the ages of 35 and 65 in New York, which is a category likelier to have children, category of women likelier to have children, only make 79 cents on the dollar. And that's in New York City, which is, supposed to be a progressive bastion and beacon of hope, which in a lot of ways it is, but you still have all of these issues contributing. So going back to the example of pregnancy and what happens when women get pushed off the job. So we had a woman call us named Takira. She worked for an agency in a state, actually in the child services division, ironically, and her doctor gave her a lifting restriction. Now, she needed a lifting restriction because sometimes she would have to carry babies and children as part of her job. And she went to her supervisor, and her supervisor said, great, you can work with adults instead, so it wouldn't require her to have to carry and lift children. Well, HR got wind of this, and they said, we can't have that. That's a liability for us, and you need to go home. And what that meant was going home without pay, which is just not feasible for the majority of workers, right? It is not a choice. It's an impossible choice. Do you stay healthy and follow your doctor's orders, or do you, go home and forego a paycheck? So fortunately, New Jersey has a pregnant workers fairness law, which provides for affirmative accommodations for pregnant workers. And she called A Better Balance. We walked her through the pregnant workers fairness law. And eventually, they shortly thereafter gave her job back with an accommodation, and it was actually a higher paying position. So she, wasn't forced to make that choice. She definitely lost out over the few weeks that she was out, but fortunately there was a law that could provide for this time for her to both, accommodate her pregnancy and keep earning a paycheck. So we work on those laws around the country. 19 states and 5 cities have passed a pregnancy accommodation law since 2013, and now we need that law on the federal level. But that's not, the pregnancy accommodation law is just one type of law that's really important to think about closing the wage gap. So the way I like to think about the kinds of laws that we need around caregiving responsibilities are for the chronology of, let's say, a woman's life, right? So a woman gets pregnant, she might need a pregnancy accommodation. So we have a pregnancy accommodation law that would provide for reasonable accommodations unless it would be really difficult or expensive for an employer to provide that. Then, hopefully, if a woman wanted to carry that pregnancy to term, she then should be entitled to paid family and medical leave to be able to take time to bond with her child without fear of retribution, while still earning an income, and then come back and keep earning money and not having to forego a promotion and keep in line, in step with male colleagues who hopefully have taken paid family and medical leave as well. Next, you have, let's say the woman needs to pump at work. So our colleagues at the Center for Work-Life Law recently came out with a report that I would encourage everyone to take a look at, finding that the Fair Labor Standards Act, which was amended as part of the Affordable Care Act, was supposed to provide break time and space for women to pump. Now, that has proven to be very helpful for some workers. The problem is that a quarter of workers are not covered under the Fair Labor Standards Act, and that means 9 million women don't necessarily have a federal right to break time and space to pump at work. And they were finding that women were constantly being discriminated against at work for needing to pump. We see that all the time in our free legal clinic. And so you have women that are pushed out because they need to breastfeed at work. So that's another barrier. Then you have, hopefully the woman took bonding leave, but as we all know, children can get sick, right? So you might need, or you can get sick sometimes. So you might need some time off to, care for an ill family member. So you need paid sick time. Now there's been a wave of passing paid sick time laws. We work closely on that. The partnership works closely on that, as well as paid family and medical leave. But we still don't have a national right to paid sick leave. Then you have caregiving discrimination, right? You might need to change your schedule because you need to tackle your caregiving responsibilities, but there's no discrimination protection necessarily for caregivers within Title VII, which is the Civil Rights Law, Employment Discrimination Law. So we see that, even New York City, we worked to pass a caregiver discrimination law, and we are fighting for a worker. Again, she's a city employee. She's a single mother with a daughter with special needs, and she asked her employer, 311, for a 30-minute push of her schedule so that she could put her daughter on the school bus and make sure that she got safely to school. Well, her employer accommodated other people who had non-caregiving responsibilities, but refused to change her schedule. They said, we will change your schedule from 3 p.m. to 11 p.m., which I see someone in the audience is just absolutely perplexed by that, because it makes no sense for a mother who asked to work from, let's say 9:30 to 3:30 to then work from 3 to 11 p.m. when she has no childcare and needs to care for her child. So you need caregiver discrimination. And like Vasu mentioned, you need childcare. You need subsidies for childcare. The average cost of childcare in New York State is somewhere around $14,000 a year, which is just not viable for working parents. So taking that segment of the workforce and looking at caregiving responsibilities, you can see why at so many points and so many junctures within a working person's life, there's just barrier after barrier to being able to stay in the workforce. So we often talk about the glass ceiling, but what we also now talk about is something called the sticky floor, which is just what keeps women, really what keeps women down, right? And thinking about the sticky floor, something I think I've been thinking about more and more is the fact that, for so many women, there's not even a floor, because the floor is just pulled out from under them. And so we really need to be thinking about this holistic approach. Yes, we need to tackle things like closing the wage gap and tightening up our equal pay laws and tightening the Equal Pay Act, and getting rid of things like asking about salary history, because that perpetuates the wage gap as well, since women start making less from the outset of their careers. At the same time, we need to be thinking about much broader solutions as well, like the ones I mentioned.
Technical break. I got it. I think. Well, full screen. Where is the screen? Oh, it's over here. Okay, I guess I'm going to stay up here because I can't see the screen. Okay. Thank you so much. I think in light of what the first two panelists discussed, I think that what I sort of have for you today is looking at sort of a micro level rather than a macro level. So I'm going to talk about the pay gap in one particular profession, and it's a profession, of course, that's of interest to all of us, legal profession. So in the last 3 years or so, there have been really a slew of lawsuits that have gotten a great deal of publicity, and I imagine many of you are familiar with, against really some of the largest and most powerful law firms, alleging discriminatory pay practices primarily, but also other discriminatory practices, management issues, assignment issues, and so on, that I'll mention. I wanted to do just a little bit of background on this particular pay gap, and then I'll say a little bit about the litigation, and to the extent there's time, and Deborah, you're going to let me know, right, what is going on with compensation systems, particularly vis-a-vis law firm partners. Okay, so you heard that the pay gap generally is 80%. That's overall in the general population, regardless of occupation. In the legal profession among lawyers, it's also 80%. So if you want to be proud that it's no worse here than anywhere else, you can, but bear in mind that this is specific to a particular job. So these are women and men using the same skills, experience, degree, and so on. The pay gap in the legal profession expands over time. This is the American Bar Foundation's after the JD study. And this is the only sort of long-term longitudinal study of women coming out of law school. They were followed for 10 years. And at every sort of check-in point, the cohort saw an increase in the pay gap. So starting with about 5% upon entering the profession, up to 20%, and I see it says 12 years, but that should be 10, okay? The problem is expands in terms of income bracket, and so the class of law firms that these lawsuits in particular target, what the After the JD program research calls the mega firm in the 251 plus category, you'll see has the largest gap there, which translates to about a 35% pay gap. We'll skip some things to save some time. So this is, most of the lawsuits that we see target partnership level pay practices, and so the National Association of Women Lawyers annual survey is now out for 2018. Female equity partners are earning 91% or 88% what male equity partners are earning, depending on whether you're looking at median or mean, and the difference in mean really has to do with, I guess, the slide I skipped. You'll see that women are, this chart shows the division by gender of different income brackets. So if you look at the very far right, over $500,000, women are only 8% of the highest earners. Okay, so that's the difference there. Major Lindsay in Africa does a biennial compensation survey, and their new report is just out, showing a 53% pay gap amongst all partners. And just if you're wondering, these data sets are different. The NAWL data set is law firms. The MLA partnership compensation study is partners. So, okay. Okay. So that's just a little bit of background. I want to say a few things about the lawsuits themselves. 9 federal and state court complaints in the last 3 years. These are largely class and collective actions. Some are state PAGA claims in California. They are targeting, and I think this is really important, in large part, these are equity partners suing regarding their status vis-a-vis other equity partners. And I think that's really important to note because there are a lot of structural issues in terms of where women stand in the law firm structure. And just sort of we know, for instance, that women are only 20% of equity partners and so forth. The general concern about what I think of as women's the attainment gap in the legal profession is not what's being challenged in these suits. So these are largely apples to apples comparisons, and I think that's really important to keep in mind. So what are the allegations in these suits? Well, the main allegation in most of them is unequal pay, and these complaints raise really striking gaps, both in terms of pure dollars of what these women take home vis-a-vis the comparators, but also in the credit assignment and point allocation. And that's sort of where the rub really is in this particular problem, as we'll see. So I just want to add that in addition to pay, sort of folded in, and this is important, I think, in terms of the larger attainment gap that I mentioned, folded into these lawsuits are factual assertions about other discriminatory practices, the denial of opportunity in terms of access to pitch sessions, business development opportunities, assignments, and so on. The problem of moving target criteria, so in other words, how much revenue do you need to bring into the firm to attain equity status? Some of these cases, some of these lawsuits allege, that the firm has a very specific policy of $750,000 in origination revenue 3 years in a row to qualify, and that number tends to shift as women advance, whereas in some there is kind of leniency afforded to male candidates. Sexist culture, and I guess I don't want to give too many examples because I'm conscious of time, but sort of one striking example in one of these complaints was the assertion that women partners were asked to serve as hostesses in a spa day client program in which female clients of the firm came in and were treated to sort of a spa experience. This is the brainchild of the all-male business development committee at that particular firm. And then ultimately retaliation for complaining about the structure. Okay. So, how much time? I'm fine. Okay. So why is lawyer compensation unequal? And I could talk for a really long time about all of these things, which I'll try not to do. But, looking at this from an academic perspective, what you can see is a system that is sort of in every way designed almost to guarantee the consequences of unintentional or second-generation discrimination preventing women from excelling on equal terms to men. And in referring to unintentional discrimination, I'm talking about structural issues and cognitive bias. I'm going to assume some basic familiarity with those terms, but I'll say a little bit more about them, and happy to talk more in the questions. These are the features that I see as kind of the toxic triumvirate of law firm compensation systems at the partnership level. And they are legacy-dependent criteria, male control, and a culture of secrecy. And I should say, this is not true of every law firm. I should also say that I'm not taking any of the allegations in any of these complaints at face value. What I can tell you is that we do have the statistics on the disparities between women and men in the legal profession, particularly at the level of the large firm. And so I think it makes sense to simply kind of look, again, sort of abstractly, given what we know, particularly from the social science literature about unintentional discrimination, and sort of propose some theories, really, about what the source of the problem is. By legacy-dependent criteria, I'm talking about primarily about origination credit. How many are law firm working associates or partners in large law firms in the audience? Okay. I guess they're not interested. I don't know. Working, right. Thank you, Melissa. This has to do with the way in which points or compensation directly is tied to client ownership. I think this is a quintessential example of structural inequality. This is a facially neutral sort of criteria for compensation that is necessarily going to disadvantage women, even on the most basic level, which is that these clients are all historically, particularly in these stalwart, centuries-old law firms, owned by men. The problem is compounded by the weighting and transfer process. So, this is the way in which firms sort of seed credit and also count credit. On the weighting, I don't think there's any reason why, if we sort of came in a fresh, sort of on a blank slate and said, how are we going to do partnership compensation? I don't know that there's any reason we would necessarily say ownership is a majority percentage of how compensation is done. It's not irrational, but it's certainly not obvious, and I don't think that it's justified in light of the clear penalties that it poses on women. Transferring has to do with how ownership is passed, and in all of these lawsuits, the allegation was, or sort of the contention was, that ownership is passed in a purely discretionary manner in which the client owner, male, decides who amongst his sort of coterie of insiders is going to inherit that credit. So you won't be surprised to know that that generally results in men transferring to men. Okay. So that's legacy-dependent criteria. Just a couple of quick things on male control and secrecy. With respect to control, and this is interesting, in the 2018 National Association of Women Lawyers report, there is some progress in this area. So now women are about 20 to 22% of managing attorneys at this AmLaw 200 level. But they are still overwhelmingly outnumbered, obviously, and in the particular cases that have been filed and lawsuits that have been filed, these are firms where largely the committees in question were exclusively or overwhelmingly male, notwithstanding this change in statistic. Obviously, this creates a problem in terms of biases left unchecked, particularly in a subjective decision-making process like partnership compensation. It's also really important to remember that women's presence on committees like this can make a difference in terms of disrupting the application of those biases in terms of creating some dissonant information. It's one of the few ways that we know of that can actually check some of the implicit biases that all of us, women included, are likely to apply, particularly in subjective context. And then secrecy, and I know that I think we're going to talk more in the discussion period about the various anti-secrecy initiatives that have been sort of brewing at the state level. There's been a lot of talk both about prohibiting employers from using past salary information, as well as bolstering employees' rights to exchange salary information. Not surprisingly, in the cases that we see here, the firms in question are firms with closed compensation systems and very intense cultures of secrecy, not only in terms of discouraging discussion about salary, but also in the sense of a complete lack of transparency about their own compensation processes. This obviously prevents women from knowing they've been underpaid. It enables sort of the moving target criteria problem that I mentioned, and it also reinforces the power structure. These women are sort of black box, have to cater to these male decision makers to succeed. So that's all I'll say about that. Since I'm out of time, I'll just answer the question whether I think that there is likely to be anything to come of equal pay litigation, that the equal pay litigation we're seeing. Obviously, litigation is never an ideal way to achieve individual remedies. It's certainly not often a way to, effect sort of major changes in culture. But I do think that these suits have legs doctrinally. I think there are aspects of the problem that lend themselves more readily to class certification, despite sort of the Walmart problem that we've seen in recent years due to the Supreme Court's decision in Dukes. And I do think they offer the potential for what I am calling trickle-down equality, in the sense that pay may be sort of an easier sort of sort of strategy, sort of an easier strategy to pursue because it involves so many discrete practices that can be identified, at least in the law firm partnership compensation structure, and yet in the face of a liability risk, the ways in which firms will have to deal with this, if they take it seriously, is to address some of the other problems in mentoring, assignment, transfer of credit, and so forth, that I think can ultimately inure to the advantage of women generally in law firms, not just with respect to pay.
Zeb?
Hey, everybody. This guy. Okay. That's a good idea. It's like a little puzzle. Is it possible just to pull that guy up so I don't have to, because I want to type? No, actually. No? Oh. Is there another, what was the HDMI cable that was like over there? That's this guy? And it doesn't thread through? And we can, oh yeah, that'll work. Thanks. Oh, that's great. Thank you. That's perfect. Thank you so much. Thanks. Oh. Hey, everybody. I'm Zev Eigen. I'm the founder and chief data scientist for Syndio. At Syndio, our basic vision and goal is to, let's see if that works. Can you see a slide up there? I can't see what's on the screen. Is to, and I'm not really, I want to go through all the slides. I just want to show you one slide. Our basic goal and vision at Syndio is to help companies solve big business problems like pay equity in a way that's both good for the business and good for everyone who is involved. So we try to do things that promote fairness and promote justice and are socially conscious. So the idea is to help sell into businesses the idea that they can use data science and technology not just to improve their bottom line profitability, which is something that all of our buyers care about, right? The people who buy our software, they might care about pay equity, they might care about rights and justice, but first and foremost, they have to run a business. And so being cognizant of the fact that there are solutions available that can do both simultaneously, that's sort of our vision and our goal for Syndio. And pay equity dovetails flawlessly with that vision. We have other solutions as well. But we noticed that there was a significant increase in states passing laws, as you probably know, and if you look at the materials we handed out, states across jurisdictions have various forms of pay equity. There's some variation across the states in terms of how they require companies to comply with the law, but the idea is simple. The Equal Pay Act, which has been around for 50 years, how long has EPA been in place? Long time. The EEOC reports that there have been very, very few cases filed under the EPA. Why? Because it's too narrow. It's very narrowly focused. So states have expanded those laws to make it easier for people to bring suits. So states vary in terms of how they protect individuals, in terms of what, who is protected, how they're protected, et cetera. But many states now have some law that instead of saying equal work for equal pay for equal work in the same establishment, which is very hard to prove, what is equal pay, what is equal work, same establishment, very narrow. They expand that to say things like substantially similar pay, or words to that effect, like comparable. And even in the jurisdictions that say equal, in the legislative notes, it often says, by equal, we mean comparable or substantially similar. So the goal is to expand the ability for people to assert rights. Note, too, that pay equity is not the same as discrimination, right? They're very, very functionally different. If I had a company with two strata in my organization, just executives and janitorial staff, and I only had male executives and only female janitorial staff, horrible discrimination, for sure. But that's not a pay equity problem, because unless you allege that janitors and your exec staff are doing substantially similar work or words to that effect, you don't have it's an apples to oranges comparison. So there's a fundamental distinction between pay equity, which is covered by the laws we're talking about today, and discrimination. Of course, companies should care about both, and of course companies should not have two strata in the organization where they're only hiring men for the fancier jobs, and selection and sorting is part of the issue why you see the 80 cents on the dollar statistics and the median numbers being overall problematic. And of course sorting is bad, and hopefully no one in this room agrees that that's good and we should perpetuate some terrible sorting issue, and there's lots of ways to fix that are part of how we help companies fix pay equity. But it's important to note the distinction between pay equity and discrimination. So what we did at Syndio was we built a piece of software that we sell to organizations, and I'll show you a glimpse of it in a second, that answer these two fundamental questions that you see up here from a statistical perspective. Because at the core of pay equity, you're answering statistical questions. There's no intent required, as is the case in other laws like discrimination. There's no intent. So like wage and hour class action and other matters, it's math. Math either it helps you or hurts you. And we have vetted the methodology that we've used at Syndio, and this is part of the methodology at its core, with agencies like the EEOC, in California, for instance, the DFEH, Department of Fair Employment and Housing, the DLSC, lots of acronyms. And it has been used by plaintiffs' counsel in class actions and putative class actions, representative actions, and on the defense side as well. And note that the first question on that screen there is not whether there's a gap, right? Because unless an organization is paying everyone to the penny the same within a substantially similar group of employees, that's the kind of SSG or substantially similar group, you got to group people correctly doing work that's similar based on skill, effort, and accountability. Unless you're paying everyone to the penny the same within an SSG, you're going to have a gap, right? It's almost axiomatically impossible or very difficult to have no gap between the distribution of male and female people getting paid in that SSG. That's not illegal, it's not immoral, it's not unethical, it's okay. But note too that there's going to be someone at the bottom of that distribution, there's going to be someone at the top. You're going to have a distribution, and that's okay. So the question is not whether there's a gap, but whether that gap is likely occurring non-randomly using standard statistical accepted criteria and indicia in the first place. Then all the laws across jurisdictions and even internationally say, okay, well, if you have a problem identified in the first place because it's likely occurring non-randomly, there's statistical evidence to suggest that the gap is not random, it's due to non-random chance, then employers may articulate defenses that explain that gap if they can account for the gap completely. And those are things like tenure, time on the job, educational attainment, as long as they are not gender related and they are job related, right? So if you're using educational attainment to explain why you're paying male janitors more than female janitors, question whether and to what extent that would be a viable explanation given that it may not be significantly job related, right? So, and again, in question 2, that's a math question, right? So the idea is you can use multivariate regression, ordinary least squared regression, all the stuff you learned in statistics and forgot about years ago to help you figure that question out. And honestly, the way this is done now in the marketplace is inefficient, and we learned this at Syndeo. So you can hire a law firm, you can hire, which they're rampant with pay equity problems, by the way. It's insane how bad. We do a lot of pay equity work for a lot of organizations, large, small, higher ed too. I'm sure we should do NYU's pay equity. I'm sure there are problems there. But we do lots of work in higher ed and the legal profession. They're some of the worst areas, I would say, frankly, surprisingly or not. But we noticed that the way this is done is very inefficient. People would hire experts like myself or people who work at law firms to do a one-and-done pay equity review. It costs a lot of money, takes a lot of time, and it was inefficient. It was, you get a report back 3 to 4 weeks, sometimes months after it was asked for, and the data are stale, they're old, changes to organization make this such that they're not really usable, and it was hard for companies to really get ahead of risk, and they were always behind it, and often they would only do it once a year, even sometimes 2 or 3 times, once every 2 or 3 years. Not a good way to make sure you're paying people the same. We had one company that told us that they gave up. They tried for 2 years using this antiquated system, and every year they had a gap. It's 5% this year, we're going to pay some money out. And this is a well-intentioned company. Next year, it's a 4% gap, we're going to pay it out, we're going to make changes. So the CEO asked their general counsel, why are we doing this? If every year I'm paying money, tell me what the business justification is. If every year I have to pay this money, why don't we wait? And if we get sued, we get sued. But I don't get the point of just paying out a gap that's never going away, because they're treating symptoms and not causes. So some of the things we mentioned on the panel today illustrate the point for the need to identify root causes of pay equity problems. So we develop software that does that. So our software helps companies find problems, fix them with non-economic means and economic means, and then stay in compliance over time. So it's an end-to-end software solution that leverages technology to help companies do this in a way that's more meaningful, that helps people and helps organizations get ahead of risk. So sometimes we sell to risk. So some companies are terrified of the legal risk or the HR risk or the PR risk of being a bad actor. And sometimes we have great organizations that work with us that are really interested in championing the rights of their employees, like Match.com. So I can mention, a lot of our clients are private. They don't want us to mention their names while they're in the process of doing a pay equity review for somewhat obvious reasons. Match.com is one of the exceptions. Mandy Gansberg is the CEO of Match.com. She announced at a conference that Fortune magazine hosted, I think, at the beginning of December, that they're one of our many clients who've used our solution, Syndeo solution, to get ahead of risk. And they care deeply about gender pay equity at Match Group. Match Group, by the way, if you guys don't know, it's a multi-billion-dollar company that owns everything. So all the dating apps like Tinder and those things, and there's a bunch of them that are international that you've probably never heard of that are like Tinder in Thailand or something. I don't know what it's called. But they own everything, apparently. What's the other one? Fish in the Sea or something? You know these? Anyway, I don't know. Anyway, they own a lot. I was trying to think of the other one they own. Anyway, sorry, they own everything. Good for them. But they care deeply about pay equity issues. And that's another industry, by the way, where you see this being an important issue to get ahead of tech. Right? So when you're hiring people in the tech industry, like what Mandy was saying, they'd love to hire more female engineers, but they have a hard time recruiting and retaining female engineers. And getting ahead of pay equity was one of the ways that she saw was, again, this idea, this theme of it being a good business rationale to do something that's also the right thing to do. Right? So Mandy's a good CEO. Mandy, the CEO of Match.com, is a good example of a company that does it for the right reasons. So you can hopefully see on the screen there is what our software looks like. And I'm not going to spend a ton of time going through it in the interest of time, but this is what loads immediately. So once you load data into our system, we have giant companies that work with us, and this is what you see immediately. So you can see going down the screen in that SSG column, You can structure the work however you want. This is how this company, this is actually real data that I've anonymized. I always use Gildas as a pseudonym. And you can see across the rows in each SSG or substantially similar group some information. And the red, yellow, green is just a simple color-coded status answering that first question. So is this gap likely occurring non-randomly? That's what you see here. And red, it means yes, from a statistical perspective, you have an issue. Note if you wanted to swap out any of the groups, you could do that. It's very easy to just swap. Here, I'll do it right now. You can literally swap. So now you see what I have there. If I wanted to go in and say, actually, I want to look at this by level, there you go. Just reran it. It'll rerun everything by level now. So it just reran all the math by level. Note across the top, there are different tabs. Here, let me swap it back. The tool takes in any data that you have, that the employer has, instantly gets it set up. Here, let me put this back. And then runs it for any comparison you want. So actually this one was, this white women versus non-white women tab was at the request of Vicki Lipnick, who's the chair of the EEOC. She asked me if we could make combos, so we did. But you can see you have one for white versus non-white, one that I just called A versus B to demonstrate you can literally do anything, and one for gender. All jurisdictions cover gender. You can create composite SSGs, so if you wanted to combine R&D, for instance, technicians, and let's say, I don't know who else, engineers, because they're all doing technical stuff, you can do that. See if I can type like this thing like this. Call it whatever you want. And it'll rerun everything for that guy, tech all. So we just created that composite on the fly, and now all the math and everything I'm about to show you is available there too. So for any SSG, if there's a problem, you can apply controls here. So remember, to answer the second question, you can articulate legitimate non-gender-based criteria on which the company relies for setting and determining compensation, as long as those are job-related. So let's say you have this problem here for technicians. In this group, you see it's red. You've got a, what's the gap? $26,000 gap without applying any controls, before applying controls. Let's apply tenure. I'm going very fast in the interest of time. Tenure in education. So it just reran everything. I can see in our technician group, that gap went from 26 to 6. The new gap is no longer statistically significant, meaning that the two controls we applied, tenure and education, fully account for the problem. And note that 84% of variation in pay and technicians' pay is explained by those two things, so it's a pretty good model. Sometimes that's not the case. If you click on any of these, just again, going really fast, you can go into a deeper dive view to help companies identify problems at any level. If you apply controls here, let's click a few, you can see everything kind of dynamically updating. The goal is to empower users to democratize access to this information so they can assess risk in a way that's meaningful without having to go through experts as sort of a gatekeeper to get this information for them. So you can see here for this R&D group, it's still red, there's still a problem. The gap goes from 17 to 9, which is nice when we apply those 6 controls, but it's still a 9-grand gap. So all of these graphs below are designed to help companies try to find non-economic solutions. Like, are there people who need to be reclassified? Are there individuals who are woefully over or underpaid? You can see in this graph, if you blow it up, anyone who's above this blue line is making more than predicted by the model. So you can quickly see there are outliers like Andy or Lowell Wood. And if you want to just see women or men, you can obscure this, you can zoom in. So now you can see men are kind of evenly distributed above and below, whereas women are mostly below that line. So like Grace Hopper, for instance, way over, way underpaid. Okay, so interest of time, not going to show you the rest of the stuff here, but there's a lot of bells and whistles here that help companies also address the cause of the problem, so not just the symptoms. So you can see here comp versus tenure, if you blow this up. Men in this group were actually paid less than women on the average when they start, but look what's happening over time. So you can see that if the company adjusts how they pay people over time, they will avoid some of the causes of the problem, not just treating the symptoms. Same thing with, like, let's look at educational attainment. Why are women with PhDs in this group making significantly less than men with PhDs, right? So the blue lines kind of go further out the more education you get. But female PhDs in this R&D group, by the way, the max is making 55.3. The lowest paid man with a PhD is making 66. So again, helping companies identify policies and practices that are creating the problem is a huge deal that avoids the problem I mentioned earlier of only treating the symptoms. And then we also have lots of other bells and whistles here, like one is this budget feature. So this helps companies figure out the precise budget to fix problems net of those non-economic solutions. So we've identified this with some calculus and some binary code searching, the precise budgets required to fix. Companies can pick how they distribute that money, evenly, proportional, lots of bells and whistles here, and then you can even customize how you want to distribute the money. So it's an end-to-end solution that enables companies to find problems, fix problems, and then stay in compliance over time. There's lots of over time kind of maintained features I can show you about too, like helping companies hire people so you're never creating a problem at the time of hire. All right, so I'll stop there.
Great. I'm going to give you a chance to get to your seat
Sure.
and for Rachel to come back. So maybe we can start at the beginning. And Vasu mentioned that the numbers that we've been talking about are really a reflection of the inequities that build up over women's lives. And they're an interplay between strict pay issues, but also broader issues of discrimination. And then Sarah talked about some of those issues around pregnancy and caregiver responsibilities. So I was wondering if you all could go a little deeper into some of the points at which we're seeing women are having unequal opportunity that end up in this pay gap, and maybe you can break down a little bit more about why we're then seeing disparities between women of color and white women even more. Vasu, do you want to start?
Sure. Yeah, I mean, it starts from the very entrance of women into the workforce. They have shown, I can't remember who did it now, but did basically a longitudinal study of women, of the gap for women, and it is, it starts the moment you enter the workforce and widens as you go through your career. And I think that the key is really the sticky floor issue that Sarah mentioned. I think the key is that once you are in these low-paying jobs, it limits your mobility to get to higher-paying jobs because you have less money to pay for educational advancement. You have less time because often your schedules are less flexible in these jobs, so you have less time to look for other work, to work second jobs, to seek education advancement, to get childcare for your children. And so really once you are in these positions, you sort of get locked in. And then as far as comparing, as far as looking at the numbers for women of color, I think what you're seeing there quite simply is the intersection of racism with sexism. And, there are many structural features to the economy that funnel people of color into low-paying jobs. From discrimination in education to hiring discrimination, there's the resume study that was famously done where if you had an identical resume that had a white-sounding name and one that had a black-sounding name, the white-sounding name would get hired more frequently than or get called back more frequently than the black-sounding name. And so, I think that I think that's where it starts, and it continues because of this. Because the fewer economic opportunities you start with, the more your mobility is limited as you're moving through your career.
Others want to join in?
Yeah, I think Vasu's point that deserves reiterating is that racism and sexism are inextricably linked. So you really cannot talk about one with talking about the other. And what you find is not just that, so the issue is, in a corporate setting, if a woman is paid less or she's discriminated against, she may be able, or she's sexually harassed, she may be able to leave that job because she has the economic mobility to do that. If you work in a low-wage job and you don't necessarily have as much economic mobility, then you're forced to keep enduring the kind of sexual harassment you may face, the kind of pay discrimination you may face, and all those forms of discrimination on top of each other. So I think another issue you have to look at is also things like minimum wage. So in the restaurant industry, there is something called the tip credit. So there's the federal minimum wage of $7.25 an hour, but under federal law, if you are a tipped worker, you only need to make $2.13 an hour because your employer is ostensibly supposed to make up the difference if tips don't make up the difference to get you up to $7.25. But what we've seen is that over and over again, tipped workers are not making minimum wage, and they are, and their employers are not topping them off because of, a strong lack of enforcement, and it just not being a viable mechanism to really make minimum wage. So you have a movement called One Fair Wage, which is basically to eliminate the tip minimum wage and to restore minimum wage for everyone. It doesn't mean that you can't still get tips. That's a farce that's kind of being perpetuated by the National Restaurant Association, which Saru Jayaraman often famously calls it the other NRA. And it's really a movement that is to close the gap there. 2/3 of tipped workers are women. They face, extraordinary amount of sexual harassment because when you need to, make tips to make a living, you have to endure really horrendous forms of discrimination, and a large majority of those are women of color. I think it's also, we've talked a lot about kind of broad-based solutions, but there's also, the inner workings of how corporations operate as well. So we started looking at something called these absence control policies, which basically are policies that are designed to make sure, generally speaking, that workers show up to work. And what they are usually point systems, right? So if you are absent 9 times, let's say, then you are automatically terminated. The problem is that we were finding is that workers, and especially women, were being penalized and given points for caregiving responsibilities. So you were pregnant and we had we have a client who needed to go to the hospital because she had a fear of miscarrying, and she was pointed and then terminated under these absence control policies. So I think, you have systems where you can look at pay equity, and you also need to look at other systems that are in place that are perpetuating discrimination. And I'll end this question with one example. I don't know if folks might have seen a recent article in the New York Times called Miscarrying at Work, which was about a supply logistics chain company called XPO Logistics. They provide distribution for large companies like Verizon and Nike, and the large majority of workers there are people of color and women of color, and they were, asking to have accommodations, again, per doctor's orders, and they were being refused accommodations. And again, this is a really heartbreaking and devastating example of this, but were miscarrying shortly after, being denied accommodations. And so you really have to look, workplace by workplace. I think it's looking into, corporations that care about PR really care, might care about this, but then you have corporations like XPO, which employs 95,000 workers across the country, is delivering your new Verizon cell phone, or it's delivering your IKEA furniture because they're the middleman, but you don't realize the devastating impact those kinds of companies are having on workers, and they don't suffer the same kinds of PR consequences because they're not the face of the issue. So I think that's just another layer of what to think about here.
Rachel or Zev, do you want to jump in? No? Okay. Well, then I'm going to ask Sarah to just elaborate on something you mentioned earlier that's in the same context. You mentioned the role that stereotypes are playing. Can you talk a little bit more, or anyone can talk a little bit more, about the impact that stereotypes regarding women's ability or even around traditional gender roles are playing in the disparities that we're seeing?
Yeah, so I think, we talk about what the pay gap and what women are capable of doing, which is an extraordinary amount. And things like accommodations, that's an area where there's a real gap in the law. But I think we need to take a step back and think about, let's say, 1978 to 2019. So 1978, we passed let's say, the Pregnancy Discrimination Act, right? That's supposed to end just pregnancy discrimination writ large, right? You walk in to an interview, the person sees that you're potentially a woman of childbearing age and says, "What are your plans for having children?" Now that you would think would be over, right? So the Pregnancy Discrimination Act comes along. You can't ask a woman what her plans are to become pregnant. You can't fire someone for being pregnant or for being a parent. But what we're seeing, and Charlotte Burrows, who's another EEOC commissioner, pointed this out on a panel we had back in October on the 40th anniversary, was that there's still this very paternalistic notion of what women's role is. So we have a client who worked in New York City for a restaurant called Twin Donut, and she became pregnant. She did not require accommodation. She just wanted to keep working, but she mentioned to her boss that she was pregnant, and he said, you need to go home and take care of yourself because you have a treasure inside there. And she took a video, not a video recording, but an audio recording of that. So there is a recording of it. And it was very bright. But what this really shows is that there are still embedded within employers, and when employers are predominantly, the bosses are predominantly men, that there's still these very paternalistic notions of what women can and can't do. We have another client who was an EMT, also wanted to keep working, and her employer said, you can either get an abortion or you can keep working. Now, reproductive choice is a huge part of this conversation as well, right? That women need to be able to determine if, when, and how to have children, whether they want to have children. Thankfully, New York State just passed the Reproductive Health Act to codify Roe v. Wade, finally, because the federal landscape is a little bit frightening right now. At the same time, to say to a woman, this is the choice I'm laying out for you, and you can either keep working or take this measure, is just absolutely egregious. I mean, it's really egregious. And I think over and over again, you see examples of are still having these antiquated notions of what women should or should not be doing vis-a-vis work life. And like Vasu mentioned, women are the primary breadwinners in an overwhelming amount of households. 68% of Black women head households in New York. It is just not a viable option for families to not keep working. But as long as we keep harboring these stereotypes and paternalistic notions of what women's place is, I think we are going to continue to see that pay gap. And I think it's a balance between wanting to highlight the progress we've made, so wanting to champion, point to Lilly Ledbetter and say we've made progress, but also recognizing that in a lot of workplaces, employers are operating from a vantage point of like it's the 1950s.
So all of you have mentioned, and you again just now have mentioned some of the challenges because federal law is so narrow and that states and localities are stepping in to the breach and are advancing what some might think are creative solutions. And I was wondering if you could talk a little bit more about what we're seeing at the state and local level and whether or not any of those initiatives have demonstrated promise or you think has promise. And if not, what should we be doing? What should states and localities be doing?
Yeah, it's a good question. It's interesting because you can see states struggling a little bit with the need to try to do something and do something in a way that's like fair and meaningful, but weighing the employers' interests and their ability to self-police with the interests of justice and the ability of people to get recourse. So one example of this is some jurisdictions like New Jersey and Oregon have expanded protected categories to these other categories, not just race and gender, but to other categories, which you can see they're very well intentioned, but they're not really thinking things through carefully. So for instance, a good example actually is sexual orientation. So both states cover fair pay for orientation. Sounds great. Totally agree with it in principle. People of any orientation, you should not get paid differently, whether you're gay or straight, or it doesn't matter. Like, that should make no difference in how you get paid. All everyone agree, great, fantastic. Now put yourself in the shoes of a really well-intentioned employer that does not want to discriminate based on orientation. Okay, so they say that's us on the panel. We're well-intentioned, we're the employers, and you guys are all the employees. What do? Do we take a poll? Okay, everybody, please report to HR to report your orientation. Like, no, it's no, and there's other criteria too, that employers don't have that information in the first place. There's one in New Jersey, you have to not pay people differently based on, I'm not joking, quote unquote, blood train. I don't know what that means, nor does the legislator. I spoke with the legislators in Oregon and said, what are my clients supposed to do who want to get ahead of these risks? Gender, we got it, we can understand how to get that information. Race, we have that information because self-report data and other ways the EOC says to get it, fine. But some of these, I get the intention, they're great, but like, what are employers supposed to do who want to get ahead of risk, not just wait to get sued? And how do we audit? How do we like get ahead of this risk? And in Oregon, they were like, oh, that's a really good point, we didn't think of that. I'm like, wow, so you just enumerated like 30 protected categories and you didn't think about employers who are trying to like do the right thing. So I get the need for pay equity across other categories, but that's one example of like this struggle that legislative bodies face where they're trying to expand rights and do things to protect rights, but it's hard to weigh those interests. The other thing that comes up a lot is the idea for a safe harbor. So like Massachusetts, for instance, and some other jurisdictions as well, have a good faith effort kind of safe harbor portal. So like it's an affirmative defense to pay equity claims if an employer is engaged in a reasonable good faith effort to audit and then make changes. That it's an affirmative defense to a pay equity claim in Massachusetts, for instance. And I think that's a good thing. I mean, we can debate whether it's a good thing or bad thing. I personally think it's a good thing because I think there are employers that we've spoken to, and there are even law firms who advise clients not to review, not to fix problems, because it might open Pandora's box and then they get in trouble. And I think that's the worst thing. I mean, obviously I'm biased because I have a company that's helping companies fix problems. But even if I didn't, like, I think it's a very bad idea to say, okay, employers, you're better off not looking and just waiting to get sued. I literally heard a defense counsel from a very large, reputable law firm on a panel with me say to his clients, you know what, I actually don't agree with Zev. Don't look, don't bother getting ahead of this risk because you're better off just waiting to get sued and paying me lots of money to defend it, like him, not me. I don't get paid. But you get what I'm saying? Like, so I think there's like these weird balances, and legislative bodies are struggling to try to get this right, get that balance right.
So the other developments I think that Deborah's thinking about that are worth mentioning are the changes in state law concerning salary history.
Oh, yeah.
And also, and I apologize, I don't have the exact numbers on this. I think it's maybe about 5 states now. It started actually, I think, Philadelphia with at the municipal level, states that, and there's a variation, that either ban employers from requesting past salary information or ban the request and reliance on past salary information. So, you know, that's an important initiative. As Zev said, it's also one that has some, you know, kind of pros and cons. Obviously, the idea there is to prevent the perpetuation of historical discrimination. So sort of accepting the idea that there is likely to be pay discrimination already with respect to somebody's former job. You are preventing the employer from simply sort of adding on to the amount that might not reflect her market value, that employee's market value. You know, employers, there are some speech challenges to these laws, which I'm not going to go into at all and couldn't possibly. But just in terms of the practical implications for employers, it is somewhat challenging. The laws do allow for voluntary disclosure in terms of, you know, the applicant providing that information. Some of them allow the employer to ask upon giving an offer. So there is some thought to how employers might be able to use salary information for legitimate purposes, but it is a challenge. And I think the objection to these laws, the principal objection from, if we go with well-meaning employers, is that they really need this information in order to recruit. So for firms that want to pay more than, say, a woman's salary, that this can be an obstacle to that. And then I guess the last piece, and there's not really a lot to say about this, there are sort of also a groundswell of laws that sort of reaffirm, I'm going to say, employees' rights to share information about their salaries. So these are laws that really impose a penalty on employers for retaliating against workers for disclosing. And the footnote here is that for most workers, retaliation for discussing pay has always been unlawful under the National Labor Relations Act. That is not a law that's sort of front and center in anybody's consciousness generally. So, I think it's certainly valuable that those from a sort of a normative perspective, kind of changing a culture that is very anti-exchange of what is considered private information. It's not just firms; it's also sort of an individual norm, a societal norm about privacy that is also at work here. So I think those are very positive, and in that context, I see very little downside, in terms of employers' interests.
I think we have a few minutes for audience questions. So if you have a question, please step up to one of the microphones in the back of the room, or I think Claire may be full service and we'll bring that microphone to you if you raise your hand.
Thank you. I thought this is a really terrific panel. It was terrific to see your tools for identifying these issues and how they might be addressed. And the content was really amazing, so thank you to all of you. I have just, I guess, a comment and then an invitation. So the New York Times this morning had a couple of really relevant articles. One about the recent flap about Paul Weiss's partnership cohort, which was, with the exception of one person, almost exclusive, was entirely male. And then there was another article about by Maggie Haberman about the collateral consequences of Me Too being that women would not be mentored by men. I think that's been said for a while as one of the sort of repercussions of Me Too. And so I would love for you all to sort of talk about what that means, but also to reflect on the fact that there are two different stories. One is sort of under diversity in law firms, another is under Me Too, but they're totally related. And so it just feels like there is a problem with siloing them, and we're never actually seeing that these things are systematic and feeding on each other, and that the lack of diversity will in turn lead to a lack of mentoring opportunities, which will in turn produce a gender pay gap. So that's one issue. And then the second is an invitation to Rachel, who just spoke so movingly about lawsuits in big law, but was also a litigant in a lawsuit against the University of Denver, where the EEOC credited what was your argument that there was a quite significant pay gap between women scholars and faculty members and male faculty members. So if you don't mind, maybe sharing a little bit about your decision to be a part of that lawsuit.
So those are two huge questions. I guess I'm going to start just by clarifying, I was not a litigant in the pay equity suit at Denver Law School. I could talk to you about my reasons for not being a litigant, but let me take your first point first, because I think you're 100% correct about the siloing problem and the connection between two movements, even if we wanted to go so far, the Me Too movement and this sort of wave of activity, both at the state legislative level and also, I think, in the courts about pay equity. It's interesting because Zev pointed out sort of the difference between pay equity and discrimination. I think there's some value in talking about pay equity outside of the discrimination context, just in terms of the optics and creating buy-in amongst employers. whereas discrimination, I think, tends to be very loaded. But structurally, obviously, the problems are the same. I think on the pay equity side, it may be that we are confusing pay equity and discrimination. I think on the sexual harassment side, it's the opposite problem, which is that the conversation around sexual harassment has been very divorced from discrimination, and it seems to be a perception that sexual harassment is a problem related to sex as opposed to a problem related to sexism, and that needs to be corrected. The pieces that are in common are, and I'll use sort of the law firm as the example, we know that sexual harassment is going to be more pervasive in companies and in law firms, right, where there is some significant gender segregation. So that tends to be reinforcing of stereotypes, to go back to that point, about women's roles, and that can perpetuate discrimination. It also is a situation where men are encouraged to sort of retrench their power structure in their own position of power. Sexual harassment serves sort of a policing function that contributes to that goal. These are just, I mean, I could sort of respond to your question ad infinitum, and I don't want to do that, you know, sort of conscious of the panel's time and other speakers. You know, in terms of, so there's a tremendous connection. And I guess I'll just say to just sort of reiterate my last point, which is I think that the notion of trickle-down equality that I sort of am putting forward is sort of aspires to maybe reach some of those internal problems, those internal structural problems that have not traditionally been able to be resolved through things like Title VII litigation. And we have a very, I think, robust set of theoretical arguments, particularly in the employment discrimination literature and feminist literature about why those kinds of structural inequalities sort of are forms of, say, disparate treatment, but it's been really impossible to address those through litigation. So that's sort of my hope with respect to the pay claims. You know, with respect to Denver, I think I'll just say something very positive about that for the moment, which is that the litigation against Denver, which started maybe 4 years ago now, settled this past May. And the consent decree in that litigation, in addition to awarding about $2.6 million to the class, includes about 30 pages of instructions regarding injunctive relief. And I think that's really important. Now, it remains to be seen how those directives are implemented, certainly, but there is an extensive effort to address sort of the internal problems that create those kinds of pay gaps to begin with, including the appointment of an independent monitor who is going to review salary annually for about the next 5 years, I believe, at the institution.
Just one thing I'll say in the service of time to your question. I think there's the law and what the law can do, and then there's culture shift also that needs to happen. And I think with something like, the obvious answer, right, is to your question is, if you have more women and people of color that are at the top of the company, it trickles down, and then you don't have a workplace that's confused about how to mentor in a safe environment that, you know, also doesn't lead to sexual harassment in the same way. I think at the same time, so how do you make that happen? Certainly that can go outside of the scope of the law, but I think there are ways that the law can also think about how to do that. So, you know, people have mixed feelings about the efficacy of sexual harassment training, let's say, but I think sexual harassment training done right, and Chai Feldblum of the EEOC put out an amazing, you know, actually prior to Me Too, an amazing report on how to combat sexual harassment in the workplace, and points to training as a really important mechanism to do that. But the training has to be done in the right way. There are lots of trainings that are not that way. But very few states have training requirements. New York State and New York City both implemented a training requirement in legislation that was passed last May, well, March through May. And so I think you're going to see, and I think New York is a good test case of how that training law may affect the cultures of workplaces. New York City is putting out a model training video that has to go into effect in April. And I think really thinking through how we can come up with really sensitive, mindful, thoughtful trainings to affect culture change is one way to think about it as well.
It's a cohort shift too. I mean, you see more of this through cohort changes over time. Like even especially law firms. Like you talk to people who run law firms now versus like 10 years ago versus like people when there was a turnover. I mean, even when I pitch to law firms to either partner, we partner with a lot of law firms, and we also do work for law firms on pay equity and other related analytics. And there's a clear shift. Like if I talk to the guy who is running the big law firm for the last 40 years and is used to a model that worked, he's like, oh, I don't know if we need anything at Paul Weiss, or we don't work with Paul Weiss, but you know what I mean? Like it's like, you hear it, and then that turns over, and then there's a new person who's in their 40s who like understands business. Like most people who run law firms have no clue how to run a business. Forget about like other issues. And the cohort change happens universally. Like you see this cohort change over time. You see it at law schools. Like you see it in the cohort of people coming through law schools compared to like when Justice Ginsburg was in law school, or people who are practicing law now, like friends of mine who are senior female law practicing partners at law firms. They tell stories that are similar to hers in law school. You see a cohort shift happening, and that's, I think, when you talk about the cultural shift, I think that's where you see that happening, and that's something that gives me hope. But without it, like you're right, the law is not going to do everything. It's not going to make the changes for the law.
Unfortunately, we're out of time for this panel. I want to thank our panelists for a wonderful discussion.